Well, welcome to those of you who are just coming in. We're going to get started now, but I appreciate there may be a few more people joining us, so we're just going to wait a couple more minutes. But good morning to everybody. Welcome to the latest webinar by 3PB Barristers. If you are a returning client, well, welcome back. And if you are new to 3PB, then welcome. Hopefully you're aware, but 3PB is a barristers' chambers based in the South and the Midlands. We have over 215 barristers in chambers, supported by a staff of around 50. And we have practice groups covering, we think, all the areas of law that you may need assistance from barristers with. But today we're here for a talk from the Property and Estates Group. And we have about 30 members of our Property and Estates Group team, and 2 of them are going to talk to you today. We're going to have 2 talks, about 25 minutes each, and then 10 minutes for questions at the end. So if you have any questions, please use the question and answer box that you'll see at the bottom. We'll keep a look at that, and then we'll ask Rob and Gavin to deal with some of the questions at the end. I'll try and get through as many as I can. I'm sorry if we can't get through all of them, but we'll give it a good go. You're going to hear from Rob Weatherley in about half an hour's time. But first of all, you're going to hear from Gavin Hamilton, who is one of our very best commercial and property leading juniors. He is a former head of our Property and Estates Group and also a former head of our commercial group. And now he is our deputy head of chambers. And today, Gavin's going to talk to you about commercial rent. So I will hand over to him now. Thank you, Gavin.
Thank you, Matthew. And good morning and welcome to everybody. A particular welcome to those of you who know me. I can't see you, I can see the numbers, I know some of the names, but if you're there and you know me, very nice that you can see me, even if I can't see you. So about a year ago, Rob Weatherley and I thought it would be interesting to do a presentation on the effect of the pandemic on the landlord and tenant relationship in the commercial context. And obviously, back then, there was a lot of uncertainty and speculation. So a year on, we're revisiting the topic, and we've each chosen a specific area. And I'm going to be talking about liability for rent in the context of particularly 2 recent cases. So what I'm going to do now, after that brief introduction, is I'm going to use a PowerPoint slide presentation. So I'm just going to go on to share screen. So there we are. So this is the title I've chosen: Liability for Commercial Rent in the Pandemic. Review of recent developments. And here we have a picture. I don't know where it is. Maybe this should be a prize for someone who can spot it. I think it might be London, but I don't know. Of a deserted street and closed shops. So something that we're familiar with. So where are we now? We're in the middle of May, about 14 months after the start of the pandemic. But we're just on the edge of a huge change, with retail businesses open again and lockdown easing in every respect. I drove into chambers today and I was struck by how much busier the streets in London were than the last time I'd been here a few weeks ago. So but the rent arrears figure for the last quarter, less than 20% of commercial rent was paid on time. So obviously this is raising huge issues, both for landlords and tenants. The tenants obviously haven't got the income to enable them to pay their rent, and the landlords have got liabilities up the chain to their lenders. So what we know, well, as always, we know so little about what's actually happening, because so much must be happening in private. Arrangements have been made, and relatively few disputes have reached the courts, which is why it's particularly interesting that literally in the last few weeks there have been 2 judgments of interest, and I'm going to look at those and the issues they've raised. Now, the first one was a decision of Chief Master Marsh in the Chancery Division. He heard the case in March and gave judgment on the 16th of April, so just over a month ago. And interesting enough, for those of you who know Chief Master Marsh, this was one of his last decisions, because he retired at the beginning of the month. And I don't know how many of you have appeared in front of him, but I was a great fan of his. I thought he was always a delightful tribunal. One of those people who was so sharp that you would always go in prepared, hopefully, for everything. And so no doubt he'll be coming back and sitting as a deputy. So this case concerned TFS stores, and TFS, the fragrance shop. They ran the fragrance shop in Westfield, and there's a picture of it, not a very good one. The second case is really quite a monumental decision, because it's three joined cases. There are the names, the investor landlords, Bank of New York, and then two AEW REIT Real Estate Investment Trust. And these three were joined together, and there were hearing dates over 4 days in November and December of last year. And then the judgment 22nd of April this year, just after Master Marsh's decision in the Commerce case. And the premises here is quite interesting spread. We've got a cinema in Bristol, so in the UK, Mecca with a bingo hall in Dagenham, and a sports shop in Blackpool, Sports Direct. And I've got pictures of all those to show you as well, just to add a bit of reality to the talk. So what I want to look at, really the topics that are covered, I'm just going to briefly touch on the first two, the code of practice and statutes and regulations, because I know Rob's going to have something to say about those. And the main issues we're going to look at are the construction of rent cessor insurance clauses, the implication of terms, and arguments by tenants that leases had been temporarily frustrated or were illegal, such that they didn't have to pay their rents. So the code of practice, this was published over a year ago, but in both cases the tenants relied on this, and there's an annex published recently, but it's a voluntary code encouraging negotiation, and it expressly does not change the legal relationship between the landlord and the tenant. It's not a bar to seeking judgment, and that's not surprising, because in the code it says government has always been clear that tenants who are able to pay their rent in full should continue to do so. And it was interesting that in the BNY case, Master Dagnall asked, obviously, what's the position about this? And all three of the tenants declined to say that they couldn't pay the rent, which is really quite surprising, isn't it? Because you might have thought, well, that would have been the obvious, sorry, slides jumped. Let's get back to my mouse. Would have been the obvious retort for them to make. So I found the right button. So anyway, that argument got nowhere. Then we come on to the primary legislation point. Now we're all familiar with this. It's complex, it's cumbersome, it's spread around. But basically, these are restrictions on what landlords can do to enforce a judgment by means of either forfeiture. Well, of course, you don't need a judgment for forfeiture, but the ways of actually securing and enforcing payment. And in Commerce, Master Marsh was quite clear that this section did not prevent the landlord from obtaining a judgment for rent. And then we've got the suspension of proceedings for statutory demands or winding up petitions. And again, that doesn't prevent the obtaining of a judgment. So just pausing there, I suppose it raises the question, well, it's all very interesting that these landlords brought these claims and they won, but so what? If they can't enforce their claims, what value are the judgments to them? But obviously they feel that it was worth doing, and no doubt they feel they've done a service for landlords generally in showing that there aren't really good defences to rent claims. And then the secondary legislation, the relevant period currently ends on the 23rd of June. And if anyone knows if it's going to be extended and when to, I'd be delighted to hear. I certainly don't know the answer to that question. So here we come on to probably the main topic that is raised in these cases, and certainly in Master Dagnall's decision, which is, 250 paragraphs, most of it's taken up with this topic. And just by way of background, the usual arrangement is that the landlord is free to insure the premises, that's the buildings, against the obvious risks of fire, explosion, etc. And as part of that, usually the landlord will also take out insurance against the loss of rent. The point being that if the premises are destroyed by fire, the tenant can't occupy them, so it's not fair that the tenant should pay. And rather than both parties losing out, as part of the insurance package, the landlord takes out insurance for that rent. And this is a standard, it's been around for years. And as often with insurance policies, the language can be a bit clunky at times, and it was different the provisions of each of the leases reviewed by Master Dagnall different, and provisions of the insurance policies were different. But essentially, that was the structure. So what the tenants, so the overarching view of what the tenant was trying to do was, in circumstances where the rent cessor clause didn't actually bite, the tenant was trying every which way to argue, well, it should be treated as if it did. So in other words, the tenant was trying to get the benefit of a rent, the rent to be paid by the insurer on the basis that would suspend his own obligation. So the attempt failed. And the main reason it failed was that the theme of the structure of the insurance to be taken out and the insurance policies is that physical damage to the premises is required. And so enforced closure is not the same. And the fact that the tenant hasn't paid the rent is not the key to the question. The question is, have the premises been destroyed? Now, both masters were clear that there was a distinction to be drawn, and they picked it up from textbook comments, Woodfall and Hill and Redman, that this is insurance by the landlord to protect his business interests in the property, not an insurance to protect the tenant's business interest in the trading that's carried on in the property. So that distinction was drawn and is critical. Then we come on to aspects of the insurance. The arrangement normally is that the tenant can't insure for those risks that the landlord has chosen to insure. And interestingly, some of the leases say that the tenant can object to a risk the landlord selected to insure if that insurance can't be obtained on commercially acceptable terms. But really the problem we've got here is the tenant's really wanting to treat the landlord as if he was obliged to extend the insurance when there was nothing either in the lease itself or in the insurance to suggest that he should. So how were the arguments deployed? So in BNY, the Master Dagnall case, the tenants argued for the implication of a term that the rent cessor should apply to COVID. Now, Master Dagnall reviewed at length the authorities, and he came to the conclusion that what the tenants were proposing was fair, reasonable, and equitable. So you might think, well, so far so good for the tenants. That was quite a result that what they were proposing was seen in that way. But the argument failed because he wasn't satisfied it was either obvious or necessary for business efficacy. And we come back to the point that it was always open to the tenants to take out their own insurance. And I suppose there's something rather glib about a tenant who's criticizing the landlord for not having taken out wider insurance when the reality is that the tenant himself could have done so. And of course, it's all done with the benefit of hindsight because nobody had thought about it in advance or at the time. And of course, these discussions have to be seen against the background of the wider litigation about insurance for business interruption. But obviously, the masters were aware of that, and it forms part of the background. Now, the argument for the tenant went a step further because there's a principle, and those of you who are familiar with this may know this case, Mark Rowlands and Bernie Inn. So basically what happens here is if I think the Bernie Inn was destroyed by fire, the landlord brought a claim against the tenant for negligence because the tenant's negligence was said to have caused the fire. And the tenant's riposte to that, and it's now treated as an accepted principle, well, you can't, given that there was insurance there in place to protect both of us from the risk of fire, you, having been indemnified by the insurers, can't claim the same loss from me, the tenant. The effect of the insurance taken out with our agreement and paid for by me, the tenant, was that this insurance was operating for my benefit. So you can't circumvent that by bringing a claim against me. Now, the argument was quite ambitious because they tried to build on that. That was a case about negligence liability. And the question was, well, can it extend to a contractual liability? Because obviously the liability for rent is a fundamental contractual liability. It's not a negligence liability. So the analogy isn't clear. But the argument failed anyway because the rent could not have been claimed from the insurer. So we come back to the point, what was the landlord required to insure for? What was the insurance actually taken out for? And really the tenants came up against roadblocks on both of those arguments. Now it's interesting, in Commerce Bank, which is a much shorter judgment, the poor tenants' advisors, the fragrance shop, they didn't handle their defense as well as they could have done. They only asked for the insurance policy a couple of days before the hearing, and they simply hadn't had time to develop their arguments or produce an amended defense. And so the Master Marsh really gave that argument in that case fairly short shrift. But if you are interested, the Master Dagnall goes into a huge amount of detail in these arguments, and you feel that there was nothing more that could have been argued by the tenants. So that's where the argument went to, and that failed. And then we came finally to the argument on frustration. And those of you who listened to my talk last year, I spent a lot of time on this, giving the background. And really where we are is that in principle, there can be frustration of a lease. But as yet, I think it remains the case that there is no reported decision in which a lease has been held to be frustrated. And part of the reason is that the authorities suggest that it's got to be a radical change on the legal relationship, and it becomes something radically different. And the problem is, certainly in the Panalpina case, where a road was closed, preventing access to a warehouse for a matter of months in quite a long lease, if you look at it in the context of the length of the lease, well, it's just not long enough. And likewise, in the BNY case, I think the Cine UK lease was for 35 years, but the bingo hall and the sports shop were 15-year leases. But even so, closure, and of course it hasn't been closure throughout the pandemic. It was effectively March till June or July last year, and then roughly November through till April this year. Add those periods together, it's 7 or 8 months. It's just not long enough. It's not long enough to make the whole venture radically different. Then we come to the sort of more refined argument, which is quite an interesting one. Well, look, if it's not full frustration, could it be suspensive frustration? In other words, can the lease be temporarily frustrated? And the tenants argued for that. But Master Dagnall was clear that that simply wasn't conceptually possible for a lease to sort of, as it were, come and go. The one point he did leave open was, well, what would happen if a lease came to an end during a period of lockdown? And whilst he didn't say that it would be frustrated, he didn't say that it couldn't be. So one can see that that is a possible argument going ahead for the future. And I think I've already covered these points about radical difference. And a further point, the second bullet there, Master Dagnall was influenced by the fact that these were protected tenancies under the Landlord and Tenant Act, if the tenant really chose to take this line that there'd been frustration, he'd be giving up those rights. Well, I suppose the answer to that would surely be the commercial one, that if the tenant's decided it doesn't wish to carry on trading, it's delighted to get out of the lease. And the fact it's losing rights for a renewal wouldn't be of concern. So frustration, it's there, it's been argued, it hasn't worked. And I really don't think that looking ahead, that it is likely to work. But it is of interest to see. And of course, the point about these cases is, and certainly on the Master Dagnall's case, which the time frame was much longer, with leading up to the hearing in November and December, the tenants' lawyers had obviously thought of every argument they could, and they'd applied a filter of arguability and relevance. And it would be disparaging to say this was all they could come up with, but I think one can reasonably infer that they didn't think there was anything else they could come up with beyond these arguments. And so that's perhaps it's not surprising, because really a lease is a very simple arrangement. You can use my premises, but you've got to pay me money for them. So as long as you're using them or in occupation, that liability continues. So it requires quite a lot of subtlety to come up with a persuasive argument. And I suppose in a way, with the implication of the terms, they got quite a way on that, in implication for the insurance. But sadly for the tenants, not far enough. Now, final arguments were raised by way of sweep up, that the obligation to pay was suspended because of supervening illegality, which is a sort of variant of the frustration argument. But the landlord's riposte was, well, you may not be able to trade, but it's not impossible or illegal to pay the rent, and there isn't an answer to that. And of course, it comes back to a disconnect, which objectively you might think was unfair. Well, if the tenant can't trade, it isn't fair that he should have to pay the rent. But that's not the test. The test is, what does the contract say? Does the contract provide that the liability is suspended? And the answer is no, it doesn't. And then there was also an argument, bottom bullet point, that had been a partial failure of consideration, but again that was rejected on the basis that it's not an overarching contractual doctrine. This is about construing the lease. Does the lease provide for the rent to be paid? Answer, yes, therefore the rent has to be paid. So that's and there's one more case of interest which I'm going to finish on, and this is a slightly unusual case because His Honour Judge Richard Parkes QC, sitting in the County Court at Winchester, heard over 4 days a 1954 Act lease renewal, again at Westfield, for the W.H. Smith shop there, which is interesting. And the particular points I picked out of this case are on the next slide. So the first point is that those of you who are transactional lawyers no doubt are arguing and in new releases being taken out for a pandemic rent suspension clause. And there was an agreement between landlord and tenant that there should be such a clause in the new lease. And the question was, well, two questions. Firstly, if the clause bit, should it suspend the whole of the rent or only half of it? The tenant originally argued for 100%, and then before the judge had to make a decision, actually conceded and said it should be 50%. And so that left the dispute as to what the trigger should be. And the decision was that non-essential shops were prevented from trading. And that was interesting because, in fact, W.H. Smith had a post office, so it was an essential shop and was permitted to trade. But the judge concluded that the fact that you're in a large empty shopping centre, if you're open for a post office, is not really a benefit. So, and then finally, on the rent, the experts were agreed that rents had fallen because of COVID by about 20%. So unsurprisingly, in the light of that, the judge decided there should be a 20% discount for COVID. But he also held that there should be no adjustment to reflect the pandemic rent suspension clause, because I think initially he thought, well, there should be. This is a more valuable clause to have in the lease, therefore a tenant should be expected to pay more for it, but he ended up considering it was neutral. But the net effect of all the figures, the comparables, the discounts, because there were other discounts apart from the 20%, the rent actually went down. It was more than halved, which is really quite surprising. So there we are, and there's a final slide, a bit blurry, I'm afraid. A busy Oxford circus. This is where we're going back to. What's going to happen with the landlord and tenant relationship? Well, just as last year, we haven't got a crystal ball, but I think what we can say is that insolvency is going to loom large. However successful the landlord is in presenting his claim for rent, the spectre for the landlord is the tenant isn't going to be able to pay, and the tenant's going to steal a march on the landlord by taking steps such that the landlord isn't going to see the rent to which he should be entitled. So that's what Rob's going to deal with, and I'll now hand back to Matthew. Thank you very much.
All right, thank you very much, Gavin. Thank you for that. What we're going to do now then is, thank you for the questions that have come in, by the way. We're taking a note of those and we'll deal with those after we've heard from Rob. So it's Robert Weatherley now. He's one of our leading juniors, specialising in all elements of property law. And remarkably, in his rare spare time, he managed to find time to write a book a few years ago as well, called Restrictions on the Use of Land. Still available, I hope, from all good legal resellers. But I'll hand over to Rob now. And as I say, questions in the question and answer box, please, and we'll try and deal with them in the 10 minutes we hope to have at the end. Thank you, Rob.
Well, many thanks, Matt. What Matt didn't say is that although I wrote a book, I've now got to update it. And I think that's far more an egregious task than I had anticipated as I'm starting to go through the updates. Well, let me start by saying many thanks for joining us today and joining Gavin and I again. As Gavin said, we did one of these seminars last year in 2020. What he didn't say is that we commented at the very end of our last talk that we'd hoped to see some of you in person for a live 2021 seminar. Looking around, I'm sitting in the same temporary accommodation that I was last year. It's raining outside and the situation seems really not to have changed so much. And I'm afraid to say the topic of today is as equally depressing as the weather outside at the moment, which is that I'm going to talk about insolvency. And whereas last year we talked about the ways in which landlords might wish to or are being affected by the COVID-19 pandemic and how that is impacting their right to end leases, the commercial side of things, the commercial atmosphere in which we're operating has of course changed. Landlords don't want to end leases if they can avoid it. They want to keep their tenants and to maximise the rent that they can receive. So with that in mind, I am focusing today on how the insolvency process might interfere with that right. I start with a bit of a disclaimer, and that is that I am not an insolvency practitioner. I am purely a property practitioner that acknowledges that the scenario in which we find ourselves is that we are going to all have to get used to dealing with insolvency issues, perhaps on a more regular basis than we previously have. Now, I've looked at the list of attendees today. There are a lot of you, and you are quite a disparate group. Some of you do property, some of you do insolvency, and some of you do in fact neither of those. That gives me quite a difficult brief, but I'm hoping that as we go through this presentation, you will see that there is something for all of you today. And what I'm hoping to do is to go from the general issues to more specific issues, shining a light on what can be a very complicated area of law, full of many different changes and alterations over the last year in the law, to some perhaps more specific recent decisions. I'm just going to do what Gavin did before, and I'm going to put my presentation on the screen. I'm hoping that that is now sharing. Excellent. Right. Well, let's start with a bit of an overview for a moment, moving on to slide 2. What's new in the last year? Well, we know that the Corporate Insolvency and Governance Act 2020, that came in. And that, of course, brought in both temporary and permanent changes to insolvency law. In addition to the 2020 Act, we have a code of practice, which I think most of us would probably describe as aspirational rather than making any substantive changes to the law on insolvency. And the last is that we have a couple of cases, in fact, 2 new cases that I have found which relate to CVAs. Now, or company voluntary arrangements, for those of you who don't do this quite so often. Now, I put the dates of the 2 judgments up. Both of them, as you will see, are incredibly recent. Thought Gavin had done well to find his from April. These are in fact May, and the decision in Carraway Guildford Nominee A Limited is in fact dated just 3 days ago. Neither of them make for very enjoyable reading. They are very long, difficult judgments, but I want to flag up some particular issues in relation to the first of those in particular, which are very much relevant to those of us who operate in the commercial sector and the commercial property sector. So let's just put this all in context for a moment. What do the official statistics really tell us? Well, predictably, they don't tell us an awful lot. There has been, as you will see there at the bottom, a 55% reduction in the number of compulsory liquidations and a 26% decline in CVAs by comparison to the previous year. Is that surprising? Well, of course it's not. It's not for two reasons. One, because there are, as we know, government schemes which are operating and still operating at the moment. And secondly, there are prohibitions, of course, on presenting winding up petitions. And we'll come to those in a moment. Gavin touched on them briefly. What is interesting about the figures, and what I wanted to reflect on for a moment, is that the overall numbers also disguise an increase in the use of CVAs in the hospitality, retail and fashion sectors. And I've seen some research recently from PwC, PricewaterhouseCoopers as was, which said that there in fact have been 19 CVAs in those sectors between June and November 2020. We are, I think, going to be seeing more CVAs, and of course, and accordingly, we need to remind ourselves of what impact those might have on a tenant's liability to pay rent. So, I'm not going to do this much more, but there are a few more statistics I want to run by. The headline point really is this. I saw this in the Financial Times a couple of days ago, and I'm afraid I couldn't put it down, which is that the headline point is the first one on that slide, which is that regardless of what the official statistics show, the number of companies, in fact, in serious financial distress, those have risen at the fastest rate for more than 7 years. And in January of this year, Begbie's Traynor, who of course does an awful lot of this sort of work on debt and corporate restructuring, they have said that around 723,000 companies are showing signs of significant financial distress. So it is not looking a particularly good picture. On the next slide, I have a few sector by sector. I'm not going to go through those in detail, but you can see that the statistics are significant. So let's have a little look at the temporary changes for a moment. And I said to you before, we're going from the general to the specific. So we will come on to the more complicated changes recently. But in terms of the temporary changes at the moment, as we all know, we have the Corporate Insolvency and Governance Act 2020. Nothing within the 2020 Acts, either that Act or the Coronavirus Act, as Gavin said, has suspended the right to receive rental payments. What it has done is to largely put the insolvency procedure, or substantially, on ice, if you like. Can you serve statutory demands? Yes, you can still serve them. But statutory demands that are served between the 1st of March 2020 and the 30th of June 2021 still cannot be relied upon to ground a winding up petition. And you'll note the reference to the most recent regulations at the bottom, which have extended the relevant period, as I say, to the 30th of June. The coronavirus test in relation to the winding up petitions, that also remains law. So at this stage, you cannot present a winding up petition for other reasons, unless the court, or you can show the court, that the creditor has reasonable grounds for believing that the coronavirus pandemic has not had a financial effect on the company, or if it has, that the debtor or company would have been insolvent in any event. So those are the temporary provisions. And as I say, that is the legislation, the regulations at the bottom for the extension. Gavin said a moment ago that we don't know what's going to happen in the future. And to a certain extent, lawyers are never masters of their own destiny, but we've been trying to predict over the last year what is going to happen. Of course, with the Indian variant, we don't know. But what we can say is very likely is that if the 30th of June deadline is not postponed further, then surely it naturally follows, in light of the statistics that we have seen, that many companies will be forced into a situation where they have to deal with the immediate commercial reality in which they find themselves. And that means that many of the companies that are coming through this period will have to engage in difficult conversations in relation to the indebtedness in which they find themselves. And of course, as we move closer to the end of the furlough scheme, the removal of the grants and the economic money that's been pumped into the economy, that is only going to become, I would suggest, more acute. So what really does this mean? Well, on a logical level, of course, it means that we're going to be talking about debt restructuring, and that necessarily has implications for the liability and the ability of a landlord to obtain the rent payments, either arrears or in fact forward rent in advance, in the future. How can this be achieved, and how can debt restructuring take place? Well, we know it takes place between either informal mechanisms, so now we're talking about the code of conduct, informal negotiations, or more poignantly, the formal processes by which debt can be restructured. So we're talking about schemes of arrangement, CVAs, and the new financial restructuring plan, which has been inserted into Part 26A of the Companies Act 2006. The problem with all these formal processes is, on a very simple level, that not everyone leaves as a winner. And one of the key points that I want you to take away from this entire talk, and I'll come to this in the context of CVAs, is that when you look at how the courts rationalise what is fair objectively speaking and what is fair procedurally speaking are often quite different things. And when you have competing stakeholders, as you do during a CVA, that have different vested interests and interests in securing their own different sums, the reality is that quite often, and more often than not, I suspect landlords would be well advised to try and negotiate or anticipate likely problems before they get to these formal processes. I'm just going to move on slightly now. I'm going on to move on to CVAs in a moment, but let's have a little look in brief at this commercial code of conduct for property relations, the informal code of conduct that has come out. We can't ignore it because it's been signed up by a number of professional associations. It is out there and it does provide some useful guidance. But as Gavin has said, it doesn't actually make any substantive changes to the law. And my suggestion, it really has been a bit of a damp squib. We were told around this time last year, so when it was going through the process of being drafted by Robert Jenrick, that it was going to be a mandatory code for all landlords. But that just hasn't happened. And the reality is that we've ended up with a situation in which we have an informal code. There is no penalty for failing to follow it. And really, most of the principles that are espoused within the code are, I would suggest, fairly obvious. What I think we can take from the code is really two things. Firstly, that it's probably aimed predominantly at smaller companies and giving reassurance or guidance to companies that can't really afford to go down the alternative mechanisms that we might be looking at later in this talk. And the second is that it does at least dovetail with some of the other reforms that we've seen in the context of moratoriums. And we've constantly heard that phrase from the government recently, that all of these processes, as they interlink, are about providing breathing spaces, as it were, for companies. I've included at page 9, I think the same quote as Gavin. Sorry, Gavin. We both took the same part, which is that there is some solace for tenants, which is that at least it says at paragraph 2, tenants who are in a position to pay in full should do so. Nothing within the code, I would suggest, though, is particularly profound. The only observation I would make in passing, however, is that, as Gavin has said, we've seen very few cases which relate to the most recent coronavirus legislation. That is probably a product of one or two things. Either people are following the code, or, as is far more likely, landlords are simply looking at the commercial situation in which we find ourselves, and commercial common sense is prevailing. I know from a number of my solicitors and from my diary that cases that I was hoping to be instructed on have suddenly settled as landlords have renegotiated issues with their tenants. So let's just move on to the moratoriums. I said to you at the start that this was going to be from the general to the specific, and in truth, it would be a fool's errand to cover all of the new changes. But the moratoriums are worth mentioning. The Corporate Insolvency and Governance Act has inserted new sections into the Insolvency Act. The provisions are quite technical, and the devil, I think, is probably in the detail when you go through it. But the core point of it is quite simple, which is that the purpose behind all of this is simple enough. It is to provide a mechanism by which companies can obtain a breathing space, there's that phrase again, to avoid insolvencies. If you look at the government guidance for this particular piece of legislation when it was in draft, it states quite clearly that the new moratorium procedure was aimed at ensuring companies can maximise their chances of survival during COVID-19 by allowing companies to have breathing spaces from their creditors. So effectively what we have here is a relatively speedy procedure at relatively low cost. What makes it so unusual in the context of the corporate insolvency regime that we have is that it's freestanding. It doesn't necessarily have to be used as part of a CVA or a restructuring plan or a scheme of arrangement. It might lead to those things, but it can simply be pursued as a freestanding respite, if you'd like, from creditors, in which informal negotiations will no doubt be pursued. So what is the catch? Well, you can see on the screen there that it is not available to everybody. A company director that does pursue the moratorium has to be able to certify that the company is or is likely to become unable to pay its debts. And there also has to be a statement from an independent monitor who must state that in their view, it is likely that a moratorium for the company would result in the rescue of the company as a going concern. Added to those two that are on the screen is a third list, which is that within the schedules at the end of the Act, there are certain types of company which are expressly exempted from being able to utilise these moratorium procedures. One of the most notable, of course, is where the insolvency or the company that's applying for the moratorium is already subject to the insolvency process. That seems quite obvious. So in terms of extensions, it's an initial period of 20 days, but it's extendable. The circumstances in which it is extendable depend upon the circumstances that exist at the end of the 20-day period. A further extension of 20 days can be pursued without permission of creditors in circumstances where the directors of the company can certify certain facts. If creditors give the support for the moratorium, then the moratorium can exist for up to a year. As for the restrictions that it imposes, those are quite logical, which is that a landlord may not forfeit for poor peaceable re-entry. He may not institute legal proceedings for forfeiture or for proceedings related to rent arrears. And lastly, of course, no insolvent proceedings may be commenced other than on application by the directors or on public interest grounds. So it's a fairly clear and obvious way that these moratoriums work, but the purpose, as I say, is to provide further breathing space, and that is seemingly what we have achieved, or what it was intended to achieve. Let's move on to CVAs for a moment. Now, these are becoming increasingly used in restructuring debt. I said to you at the outset of this, I could not cover all types of restructuring arrangements. And the reason I focus primarily on CVAs is that they tend to be used in the commercial property sector rather more than schemes of arrangement. We don't know how these new restructuring plans will come into play or what exactly those will, the impact that those will have. So CVAs are something we can expect to see, and I want to focus on those particularly because they have an impact upon rent, and also there have been, as I say, 2 recent new cases. So what is interesting about CVAs? Well, as we know that they are a way of restructuring debt, or in the case of individual IVAs, I'm not going to cover those today. The core point, I suppose, I'm trying to make in all of this is that a CVA, as we know, is a way of finding a compromise. It's a compromise, yes, between creditor and debtor, but it's also a compromise between different classes of creditor. And the core point I really want to make, and this is particularly true of the case of Lazari, which is the most recent authority, is that there is often a gap between what might be seen as procedurally fair or substantively fair and what actually a court may sanction as perfectly fair and permissible under the CVA regime. So how do they work? Again, I'm saying this for those of you who do these less frequently, but we all know or should know that they relate to unsecured creditors only. Unsecured creditors vote on the proposal. If 75% of those entitled to vote approve it, then the CVA is passed, and all creditors of the company who received or are entitled to receive notice of the meeting are bound by the terms of the CVA. A number of issues then arise in the context of the rent arrears situation that we are discussing today, which is firstly, can CVAs be used to vary future rent payments? Not because arrears, but payments that are going to arise under the lease at a later date, should the company continue in the CVA. For that matter, the other questions are, to what extent may a provision in the lease be altered? What happens if the CVA unfairly favours one set of landlords over another? And what happens, for that matter, if the CVA only passes because one particular group of individuals comprised in the CVA are not being particularly impacted? These were the sorts of issues that we were seeing arising in Lazare. And I want to cover it in some detail because it is, as I say, of direct relevance. So I have there briefly on the schedule or the slide, the two scenarios in which the tenant, or rather an objector to a CVA might object. That is, that they can say that it unfairly prejudices them, and that is primarily the issue I want to look at. Just by way of context, those of us who deal with this will know that unfairness in this sense has to be looked at in two different ways. It's vertical fairness, that is to say, it is whether, comparing the outcome of the CVA and the outcome of liquidation, there is, should we say, a bottom line upon which the outcome will be better in the CVA. So in other words, on a vertical level, it is the irreducible minimum, that is the word that the cases use, below which a CVA cannot go. If the CVA is a worse outcome than liquidation, then it is not a fair outcome. The second is the horizontal comparator. And this is what I particularly want to look at, which is that one of the outcomes of CVAs is that they can unfairly impact upon landlords, particularly where there are other classes of creditor that are less likely to be impacted, but the rent, or rather the landlord going forward, is effectively subsidising reduced rent payments for a company that is more or less insolvent. So I'm going to move forward now to the Debenhams litigation. This was a 2019 case. In the retail sector, there are only two cases that have got all the way through in terms of oppositions to CVAs. There are only two cases. And the Debenhams case, many of us will know about it already from the media, but Debenhams, that large and formerly successful retailer, proposed to enter into a CVA to address what it effectively regarded as unsustainable property costs. And effectively, what happened is that Debenhams looked at the rent that they were receiving, they looked at the incomes they were receiving from particular branches, and they grouped each branch into a particular category of landlord. And the CVA that arose, or they were trying to propose, amongst other things, suggested a large and substantial rent reduction under the lease in terms of future rents, and effectively certain stores were taking or had a larger reduction in rent. They also proposed a removal of the liability of the company for dilapidations claims. And lastly, they also wanted to remove the right of the landlord to terminate the lease by way of a forfeiture clause. Now you can guess who the applicants were. The objectors in this case were the landlords who were being unfairly disadvantaged. Now the grounds upon which that claim for opposing the CVA were made are on screen at the moment. But fundamentally, the question that arose, or the questions that arose in the case, included two things. Firstly, whether a CVA could effectively abrogate a term within the lease which entitles a landlord to forfeit. And secondly, whether the CVA could superimpose a new lower rent in place of what had already been agreed between two individuals, the lessor and lessee, in an arm's length transaction. Now, I'm not going to go through the next slide in detail, because this should be fairly clear to those of you who do property, which is that a right to forfeit is a right in property. It doesn't attach simply to the lease. It's a right which is attached, in fact, to the reversion. And in those circumstances, a CVA cannot remove that right. But the more fundamental question, really, is about how and in what way a CVA can interact with a landlord's entitlement to future rent. The short answer is that it will depend on the wording of the CVA. That said, I put online a key quote which is helpful in regards to this question. So this is from Lord Neuberger, or Lord Justice Neuberger as he was then, where he says, "It appears to me that the rent falling due after the CVA should by no means necessarily be expected to be caught by the terms of the CVA, even if it is capable of being so caught. It strikes me that, at least normally, it would seem wrong in principle that a tenant should be able to trade under a CVA for the benefit of its past creditors at the present and future expense of its landlord. If the tenant is to continue occupying the landlord's property for the purpose of trading under the CVA, and hopefully trading out of the CVA as well, he should normally, as it currently appears to me, expect to pay the full rent to which the landlord is contractually entitled." Now, the reason that's interesting is because of what comes next. Now, this here is Mr. Justice Norris's final concluding comments about how a CVA interacts with the liability to pay rent. And he says, well, here common justice and basic fairness require that the landlord should receive at least the market value of the property he's providing. He should not subsidise other creditors, but nor should they be compelled to overcompensate him. So echoing the same sort of comments that we heard from Lord Neuberger. To that basic principle, this is the important part, should be engrafted the principle that a contractual rent should be interfered with, this is the key part, to the minimum extent necessary in the circumstances, the modification being limited to what is necessary to achieve the purpose of the CVA. I hold the CVA that reduces rent under an existing lease is not automatically unfair as breaching some fundamental principle of common sense and ordinary justice. The ability of a landlord to bring an end to the varied relationship renders it fair in this case. So what we really get from that is three things. We understand that future rent can be altered by the terms of a CVA. We understand that the starting point should be that landlords normally receive at least the market value for future rent. And the last thing is that Mr. Justice Norris is seemingly indicating that the contractual rent could be or should be interfered with only to the minimum extent that is necessary. And it's those words that I leave you on because this is particularly relevant to the Lazari case, which came out literally only on the 10th of May. Lazari Properties is the case that you may have seen reported in the media. It's a case relating to New Look, well-known but not particularly brilliant chain of shops of about 400 in the United Kingdom. And it's a particularly similar situation to what we've been seeing across the board, which is that the directors of the company had to close all of their shops in the United Kingdom. Their online presence was less lucrative than their shop or high street presence, I suppose you could say. And the effect of the pandemic, in the director's view, was that effectively they would not be able to continue as a going concern without restructuring their debt. So they proposed a CVA as part of the way around that. And the creditors that were entitled to vote in the CVA really fell into two broad groups. Firstly, you had landlords, in fact, quite a large number of landlords. And secondly, you had a number of unsecured creditors. As part of the proposal, and you can see this on that slide, slide 19, the process of restructuring CVA was proposed predominantly to amend onerous terms within leases. It was approved by 81.6% of all the creditors. The problem was that the reduction, if you'd like, in rent, or the reduction in the entitlement to rent going forward was not spread evenly. So the nature of the creditors and the categories of creditors were separated into different groups. If you were a category A landlord, you did fairly well out of the deal. Category A landlords were those types of landlord that were absolutely essential to the continued presence and operation of New Look. So we're talking about distribution centres here. As for category C landlords, they got a rather poor deal. They were effectively underperforming stores, and the CVA was being used as a mechanism to reduce the rent arrears, to compromise in full rent arrears, in fact, actually, to reduce the rent payable going forward, and to effectively put it on a turnover basis. Some of the changes that were being proposed are now being shown to you on slide 21. And you can see there that really what was being proposed was actually quite significant. The grounds for opposing were multifarious, and quite frankly, they're extremely complicated. It's a very long judgment. It is, to a certain extent, and only a lawyer would say this, an interesting judgment. But the core point, and in the way, and as far as it interlocks with the Debenhams case, is really ground 3, because one of the arguments that the objectors made to this is that they said they were being unfairly prejudiced, or rather a class of the, I'm being told that it's time. I'm just going to finish this last part off. Apologies, Matt. I won't be much longer, but this is one of the key points. I want to leave it with everybody before I move on. But the key point really is this, which is that the applicants were being told or were arguing that they were being unfairly prejudiced because the only reason the CVA passed in the first place was because a large number of other creditors who were not really being impacted to any significant extent were happy to waive it through. So there was a large group of landlords that were placed at a substantial disadvantage because effectively the way the CVA works, of course, is that you need a majority of 75%. If you have a majority of 75%, it binds everybody. So they argued that that was not fair. They also argued that the nature and extent of the various modifications of the lease were themselves unfair as well. And of course, one of the arguments that they raised is that they picked up on the wording of the Debenhams case, which is that any CVA should only interfere with the terms of a lease and the terms of the payment of rent to the minimum degree necessary to make the CVA effective. Now, I am going to have to hurry through. I did wonder whether I might go over. Matt is looking at me as if to say, yes, we all knew that you would go over. There we are. But the key really part is this, and this is Mr. Justice Zaccaroli's decision. And he says, I do not understand Mr. Justice Norris in the Debenhams case to have laid down a rigid test that the CVA can only escape a finding of unfair prejudice if it is at least market rent, if at least market rent was paid and the interference was necessary to achieve the purpose. If he did, then I respectfully disagree that there is such a rigid test. I can conceive considerable force in the contention that a permanent long-term reduction in rent imposed on landlords without an option to terminate would be inherently unfairly prejudicial. But then effectively what he says, and this is the last part of it, is that in relation to the broader argument, the long-term modifications was unfair, he says, I consider that the answer is provided in the landlord's right to terminate, provided that the terms offered to the landlords upon exercise of that termination right are at least as beneficial as the relevant vertical comparator. In other words, what he was actually saying is, well, it was fair in this case because I'm clarifying Mr. Justice Norris's comments. It doesn't have to be the absolute barest minimum. We take into account all of the circumstances, that this is a balancing act, and that provided that these particular creditors were given, one, an opportunity to get out of the CVA if they didn't like it, and two, they achieved at least what they would get out of a liquidation, then that was something that Mr. Justice Zaccaroli regarded as fair. And that's why we have on that page, getting scowled at my Matt, so I'm going to end it here. That is why we have a reference on the last page to the vertical comparator. I think what I'm going to do, it is an interesting case, not an interesting case to read because it takes a very long time, but there are some interesting points about it. When you receive the notes, and these will come out to you today, you will be able to read and digest this a bit more. I think the reality is that dealing with this in 25 minutes, there are an awful lot of changes in the law of insolvency. And for those of us who do this sort of work less frequently, the problem with our legal system is always that it's a patchwork of reforms and changes. But the patchwork that we've seen over the last year is so considerable that it is very difficult, I think, indeed, for any of us to keep up with all the changes that have been made. I'm going to leave my conclusions there and hand back over to Matt before I get told off. And I hope that most of you have found something in there that assists you.
I'm not going to tell you off, Rob, but the new look lawyers might do, I suspect. But there we are. Right, thank you very much, Rob. Thank you, everybody. What we've had a few questions come in, and Gavin has quite diligently answered quite a few of them as we've been going along. So we'll take just a couple of minutes now. I'm conscious of the time, of course, but let's just deal with one for Gavin, perhaps, which is what can a tenant do in respect of rent cessor for COVID?
I suppose the two things I think that the tenant could do is to persuade the landlord to increase the scope of the insurance cover that the landlord takes out that will be covered by rent cessor, so as to include closure due to government regulation. And the answer to that is going to do, well, it's a choice for the tenant, isn't it? Because it depends on the terms and the cost on which such insurance is available. But if it's available on acceptable terms, the tenant should agree to the landlord taking it out and paying for it. And the alternative, of course, possibly if the landlord refuses to do so, is for the tenant itself to take out such insurance. And I don't know how those risks are looking on the market and whether that would be an alternative, but that's something a tenant can do. And of course, someone might take the view, well, when we're nearly out of this, the risk isn't there for the future, but it's all about, it's a judgment call, isn't it? So there are things they can do. Thank you.
Thanks, Gavin. And certainly things for people to think about that they wouldn't have been thinking about 18 months ago, I guess. One for Rob then. Why is it that you suspect schemes of arrangement are used less often than CVAs to restructure debt in commercial property?
Well, I suppose there are probably two principal reasons. The first is that a CVA can only be used to restructure unsecured debts. So it doesn't bind against preferential creditors like HMRC, and it doesn't really bind against secured creditors either, because they're not entitled to vote in on the CVA. So you tend to find that it's used, this I suppose is why it's used particularly by companies like Debenhams and New Look, companies that have large amounts of unsecured debt, with large property portfolios like them. It's particularly useful. The other issue, and of course the main difference between, one of the differences between a scheme of arrangement and the regime under the CVAs, is that in a scheme of arrangement you have to group all of your creditors into different categories effectively, and then in order to secure the scheme of arrangement, in order for it to be approved, you have to get 75% in each category. And I suppose the risk is with landlords that they may be grouped into one category, unfairly prejudiced, and may in fact effectively exercise a veto, if you'd like, over the scheme of arrangement. Whereas in CVAs, we've seen in Lazari, the situation is quite different, which is that you can have a scenario in which actually, going forward, landlords get a comparatively poorer deal than those other unsecured creditors who are happy to waive it through. And that was really a component when you look at Lazari of why the case came to court. Okay.
Thanks, Rob. Yeah, that's really helpful. All right, I think we'll do one more question then before we wrap this up. I think probably a question for either of you, but let's go to Gavin, perhaps. Would non-compliance with the code of practice have costs consequences?
I think it could do, yes. If the tenant was able to show that, well, it's hard to see, isn't it? You need to know the background. I suppose the tenant loses. Would the tenant lose and say, well, I shouldn't pay the landlord's costs because they didn't try to negotiate? To which the riposte might be, well, show me the evidence that you tried to negotiate. Because that was one of the points actually in the BNY case. I made that reference to what the judge had said about that. And he said that the tenants have criticised the landlord, but in fact, I think it's the tenants who failed to engage with the process. So it's going to be very, very sort of fact and nuanced as to whether. But in principle, I think that the argument might be available. Yes.
Can I just give a follow-up answer to that, which is a much more junior angle than Gavin's, which is that I suppose it depends on what level of tribunal that you are at. But I suspect that if you raise that argument with a district judge and it's a judgment for 50 grand, 100 grand's worth of rent, for rent arrears, something of that description, or you're proceeding along that route, I think some district judges would probably find an awful lot of interest, I suppose, in if you said, well, the pre-action correspondence has been very little, they haven't engaged with the code of practice, I suspect there would be some sort of argument in relation to costs, yes. I suspect with that level, district judges, it may well find favour.
Thanks, Rob. Yes, I think that is going to be fact specific, but I can see certainly district judges having sympathy when they have their wide discretion on costs, having sympathy with tenants if they can show they've engaged there. All right, well, thank you very much, gentlemen, and thank you to everyone for coming. Sorry we've gone a few minutes over, but we're going to wrap it up here. I think we've answered everyone's questions, either live there or on the chat. But if anyone has any other questions or anything that arises, then do get in touch with us. We're very happy to help. As for us and our webinars, the next one from the Property and Estates Group is coming up in June. That'll be with myself and Jack Webb, dealing with elements of residential landlord and tenant law at the moment. So please do come along to that if you can. Any feedback that you have, please provide it with us. And as Rob said, we'll be sending out the notes later today. And a recording of this will be available online within the next few days for a short period of time if anyone has missed it or wants to come up again.